This video is brought to you by Against the Flow of Mississippi. Against the Flow of Mississippi is a book about Jake Fayard, a Marine veteran who is unhappy with the political machine running the state of Mississippi. He decides to fight the corruption from the inside. Jake will face more challenges than he ever has and will stand up for what he thinks is right. His notoriously hot temper will push him to the edge of murder, along with his friend and brother Kobe Barhanovich. Together, they will fight the system and give the power back to the citizens of Mississippi.
Against the Flow of Mississippi was written by Anthony Oksenholt and was published by Oksenholt Biloxi Publishing, LLC. A link to the book will be placed in the description below.
Yeah, this a revolution in our time. Everybody's fighting, change coming, yes. That's why it's an acronym for riot. Everybody has a voice. Don't you dare stay silent. If you say nothing, you are an accessory to violence.
They've had their say. Seems like they've had that kind of say around here for too long. Look, I had to stand up for myself alone. I went in there to remind them that somewhere in this world there's still a little law and order left. To let them know in the only kind of terms that their kind understand is that they can't bribe or threaten their way out of what they did. To let them do this to me and get away with it, and you give them the eternal right to do the same damn thing to any one of you.
Access 228, your host, Anthony Oksenholt, where we report the facts and we are not for sale. If you have a news story or something that's on your mind, please feel free to give us a call at 228-337-2099. Be glad to have you on. Thank you for listening, and we do appreciate all that you do to support us and keep free and independent journalism doing what we do best.
What you are witnessing is real. The participants are not actors. They are actual litigants with a case pending in a California municipal court. Both parties have agreed to dismiss their court cases and have their dispute settled here in our forum, the People's Court.
All right, y'all. So we're going to talk about the University of Artificial Intelligence School of Law. This is why people shouldn't use AI. Oh, God, this is so funny. Order denying motion to disqualify counsel. Before the court is pro se plaintiff Yuri Petrini's motion to disqualify counsel. In some plaintiff moves this court to disqualify several attorneys in their respective law firms from further representation of any party in this action. Before the instant motion was filed, the action was administratively consolidated with two other actions filed by plaintiff due to common questions of law and fact. The court presumes plaintiff's request for disqualification would apply to all three actions. Motion is opposed by defendants and their counsel. Defendants argue that plaintiff's motion is premature. For instance, the proceeding in all three actions have been stayed due to the numerous pending motions before the court. Gee, I wonder who filed most of the numerous motions. I'm going to guess that Mr. AI Law Degree did. Further, several attorneys plaintiff seeks to disqualify are no longer defendants. While Curry, Johnson, and Myers, PA, still remain as a defendant in all these actions, there is no denying the posture of these three actions has greatly changed since the instant motion was filed. Determining whether disqualification is appropriate is a delicate procedure, particularly when a motion to disqualify comes at an early stage of the litigation. It would be premature to disqualify attorneys from participation when so much concerning the final issues to be tried is unknown. Let's stop right here. So he's suing judges to try to get his criminal case untriable. And now he's suing attorneys that are representing defendants in his bullshit lawsuit so that they can't represent their clients. Is this how they practice law in Sao Paulo and Italy and wherever the hell else that son of a bitches live? I know it ain't how they do it in Miami. It would be premature to disqualify attorneys from participation when so much concerning the final issues to be tried is unknown. Considering that the motion was filed in the early stages of this litigation and the current posture of all three actions has greatly changed since that time, the motion is denied as premature. Alternatively, in the opposition to the motion, defendants note there are issues with plaintiff's citations to case law. Here comes that AI law degree, y'all. Folks, here we go. For example, plaintiff cites U.S. Fidelity and Guarantee versus Minor, blah, 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 which does not exist. Aw, did AI get it wrong? The Westlaw citation leads to Lewis v. Vision Value, LLC, which is actually Eastern District of California, not even in the Southern District of Mississippi, which is funny. And the correct case citation for U.S. Fidelity and Guarantee case discussing disqualification appears to be U.S. Fidelity and Guarantee versus People's Bank, Biloxi, Mississippi. The plaintiff acknowledges the citation error and provides the correct case citation in his reply. Plaintiff says the error was not the result of his reliance on generative artificial intelligence. Rather, it was a Scrivener's error attributable to his visual disability. Boy, how many disabilities you got? You know, I'm going to stop right here and call bullshit on some of the things that he's saying. You know, he's got narcolepsy, he's got all these disabilities, but he told me he was a licensed pilot. How can you safely, now, you know, I'm interested in getting my pilot's license, and I plan to at some point in my life before I die. But I want to know how you can have all these debilitating diseases and fly a plane, or was you just full of shit when you said that? I mean, you did tell me that you were looking to buy a fucking Cessna Citation. Oh, God, I wish I had a fucking, I wish I had that pin on me every time I ran across these sons of bitches with all the lies and shit that they told, and I hate a fucking liar. The court can understand and excuse a simple typographical error. However, that does not appear to be the case here. Instead, the entire 7-digit Westlaw citation is incorrect. Moreover, the Westlaw citation is not random. It is the correct Westlaw citation for a different case from the Eastern District of California. To be clear, this is not the court's first time dealing with what appears to be a pro se litigant's use of AI to prepare filings. Didn't Judge Lusk say something to you about using AI and how it was probably not a good thing to do? The court recognizes this specific type of citation error, the generation of an incorrect Westlaw citation. It is a common result of a pro se litigant's reliance on AI to prepare filings. It is no secret that generative AI programs are known to hallucinate non-existent cases, and with the advent of AI, courts have seen a rash in cases in which both counsel and pro se litigants have cited such fake, hallucinated cases in their briefs. What is that effect that they call it? The Shazam effect? In any event, plaintiff's explanation does not explain the reason that for his other citation error identified by defendants, arguing that the firm cannot simultaneously defend against allegations of its own misconduct while representing municipal interest. Plaintiff cites Dresser Industries again, arguing that when a firm simultaneously serves as a defendant and defense counsel, disqualification becomes mandatory. This case does not stand for either of these premises. These non-existent or hallucinated legal cases are indicative of plaintiffs relying on AI to prepare his filings. Oh, your AI law degree catching up to you, buddy boy. Just like your fake bar exam that you're supposed to take in October that doesn't exist. Courts exist to decide controversies fairly in accordance with the law. This function is undermined when litigants using AI persistently misrepresent the law to the courts. AI is a powerful tool. No, it's not. AI is a bullshit tool. I'm going to tell y'all, the court is saying AI is a powerful tool. AI is about as powerful of a tool as a left-handed crescent wrench. That when used prudently provides immense benefits. When used carelessly, it produces frustratingly realistic legal fiction that takes inordinately longer to respond than to create. While one party can create a fake legal brief at the click of a button, the opposing party in the court must parse through the case names, citations, points of law to determine which parts, if any, are true. As AI continues to proliferate, this creation response imbalance places significant strain on the judicial system. I agree. I agree with that. Here, the court's concern is not necessarily what appears to be the plaintiff's use of AI to prepare his filings. Rather, it is his compliance with Rule 11. Even if plaintiff did not use AI to assist with citing legal opinions and holdings, he must still comply with Federal Rule of Civil Procedure 11. Rule 11, which applies to all parties, including pro se litigants, provides that when a paper is submitted to the court, a party certifies to the best of the person's knowledge, formed after an inquiry, reasonable under the circumstances, the legal contentions are warranted by existing law. So, under Rule 11, all parties, including pro se litigants, must confirm the existence and validity of the legal authorities on which they rely. This is because the central purpose of Rule 11 is to deter baseless filings in district court. Plaintiff's memorandum in support of the instant motion contains citation errors to which appears to be the reliance on AI to prepare his filings. At least one of these citation errors contained in a misrepresented holding. While plaintiff may view this as over-scrutinization, his citation errors have caused this court to question the veracity of the subject filings. Therefore, in the alternative, the instant motion is denied for this reason. In other words, they're tired of your bullshit. As a final matter, defendants move for Rule 11 sanctions and ask the court on its own to entertain the imposition of Rule 11 sanctions. The court declines to entertain the imposition of sanctions under Rule 11. First, to the extent defendants move for Rule 11 sanctions, strict compliance with Rule 11 is mandatory. I agree with that. And Rule 11C2 contains several requirements which do not appear to have been met here. Second, while the court could sua sponte order the plaintiff to show cause why his conduct has not violated Rule 11B, the court instead concludes that the admonishment is most appropriate at this juncture. You know what, Your Honor? I'm sure you'll never see this video. But I'm going to go ahead and let you know that you can admonish him all you want to. It's not going to stop him from doing his bullshit and wasting the court's time. I hope you change your mind. Many judges opt to warn rather than sanction pro se litigants who have improperly used AI instead of imposing sanctions. Hold on a minute now. Hold on. He's going to take the bar exam in October, remember? He's in law school, remember? He's not your standard pro se litigant. Hold him to the same standard as any bar attorney. He wants to play the game, let him play the game, baby. The instant motion was filed early on in this action. Since then, the court has admonished plaintiffs for other reasons. So you've already admonished him. With regard to the specific issue, however, plaintiff represents he has since obtained subscription to both Westlaw and LexisNexis, I doubt it, to ensure the accuracy of his legal research and citations. Further, he has subsequently made other efforts to demonstrate he has verified the accuracy of his citations. Lastly, because the court did not reach the merits, it did not examine whether the motion brought for any improper purpose, such as a procedural weapon under Rule 11b1. Accordingly, the court admonishes plaintiff and cautions him that future filings with citations to fictitious cases and or holdings or future filings which do not otherwise comply with Rule 11 may result in sanctions, including but not limited to the striking of filings and the imposition of monetary penalties. Okay. Let's talk about that last paragraph, because that last paragraph is a shot across the bow, in my opinion. If Yuri keeps filing his bullshit, AI generated whatever the fuck, the court's going to hit him with sanctions. Where have I heard that quite recently? Oh, yeah, Judge Luss said that too in municipal court. Hey, Yuri, have you realized that your AI law degree isn't exactly worth the paper that it's not written on? God, you're so dumb. I'm I'm almost ashamed of myself at even doing these videos sometimes, because it's so pathetic. I equate it with, well, I don't know how to equate it. Oh, God. Anyway, y'all have a good day. I thought I would share because it was shared with me and I found it funny.